Burns against Varriale. Mr. Murray, good afternoon.
Good afternoon, Your Honors. May it please the Court, Judge Kaye, I respectfully request that I be allowed to reserve 1 minute of my time.
1 minute, yes.
Your Honor, I note at the outset that there's sort of a coincidence in the calendar and the juxtaposition of this case that has such profound implications for workers with the day after Labor Day. I think, Your Honor, the most important thing here is what the appellate division did wrong. Obviously, we think that it erred because it did not exercise discretion and it substituted a rigid rule of flexibility in lieu of flexibility, which is what the principles this court articulated in Kelly versus State Insurance Fund nearly a quarter of a century below. There's a litany and a parade of horribles here that are conjured up by the respondents to suggest that there is something here that makes the likelihood that Officer Burns would have continued to receive the benefits in the future highly unlikely.
Well, there is a degree of uncertainty here that's not present when it's a total disability, isn't there?
That's true, Your Honor. As I said in my brief, nothing is perfect and you can't predict everything with absolute certainty. But I respectfully submit that if you're going to look at who was speculating here, the appellate division was speculating far more than the trial court. Let's look at the facts. What happened here, and the key is the exercise of discretion. As this court has said in a number of times involving cases involving Section 29 of the Workers' Compensation Law, that it's an exercise of discretion by the trial court, and that exercise of discretion should not be abused absent a clear abuse of discretion. What happened here? Judge Teresi looked at the facts of this case and said, yes, this gentleman is not permanently totally disabled, but he is significantly disabled, such that he ultimately was required to retire involuntarily because of the pain attributed to the accident. Second, what's the likelihood that he's ever going to receive less than the $400 a week? Prior to the accident, and this is all uncontroverted in the record, Officer Burns was making about $70,000 a year.
Mr. Murray, if I
Yes, Your Honor.
just so I could be clear, are we arguing over who is going to pay the attorney's fee on the money that the plaintiff received? In other words, when you settle a case for, let's say, $300,000,
right,
you have to take out of the $300,000 the lien, right?
Correct.
That comes out, and then there's an amount of money left.
Correct.
And normally the attorney will get 1/3 of that.
That's correct.
But that same money, that same, let's say, whatever amount it is what is going to be applied going forward to reduce or, in fact, eliminate the workers' compensation payment. And it's that fact that you want to have recognized. And so aren't you really saying that the 1/3 that the plaintiff paid to me to settle this case ought to be paid by the workers' compensation carrier, because it's the one that's benefiting from even the other $200,000 that I
Well, yes, Your Honor.
So that's what we're down to, is really an argument of who's paying not necessarily your, but a plaintiff's fee in a case where there is a settlement that leaves money in the pocket of
who should bear the expense of litigation?
So in theory, just to carry this out, if you have a case like this where let's say all of the roughly $200,000 that's left will be applied in futuro to the workers' compensation to the benefit of the injured party, because it's offsetting the workers' compensation in the future.
Right.
Plaintiff will pay no money to you or to the plaintiff, to his own attorney. The state insurance fund in this case would, because at least in theory the argument is all of the money that I've regained is going to pay in futuro what the workers' compensation board would otherwise pay.
Well, it's a question of apportioning the liability between the worker himself, who benefited from the judgment, as well as the workers' compensation, or the carrier, who has benefited as well by virtue of the fact not only is he going to get back, the carrier is not only going to get back the lien that it's paid, but it's also not going to have to pay during the credit or holiday period subsequently what it otherwise would have had to pay.
But that's the
and
money.
That's the principle that this court articulated in Kelly versus State
Mr.
Insurance
Murray,
Fund.
the carrier did reduce the lien by 38.4%. Was that representing past litigation expenses?
The 38, it's 34.82, Your Honor.
Okay.
That is the percentage, that's the legal fee applied to the total recovery. Then the question of that 34.82%, then you look at that and you say, okay, you apply that 34.82% to the amount of the lien that's recovered by virtue of the settlement proceeds. Then you look at what is the present value of the future benefits that the carrier would have continued to have to pay, but for the fact of this settlement. And then you say whatever the present value of that is also a benefit realized by the carrier, and accordingly you must also take the 34.82% and say that's the legal fee that he ought to bear. That's how that works.
As I understand it, there's no disagreement with the principle as you stated it. The only thing that we're arguing about, or that you're arguing about, is whether that future benefit is too speculative to be present valued and paid out today.
That's the crux of the argument, Your Honor.
Suppose, let me make a suggestion. As I understand it, the Supreme Court here said pay him, was it $50,000? I can present value it. You should pay the man $50,000 in attorney's fees right now. The appellate division said it's too speculative. You pay him nothing now, and you let him come back later.
Correct.
Is there a third possibility? Why don't they pay, what is it, $400 a week? Why don't they pay a third of it every week?
Well, that...
Until somebody says that's not right.
Well, Your Honor, that entails having the worker have to come back. First of all, that's the...
Can't the board order it? Can't the board say pay him one-third of the $400 every week until the... But if it turns out he's not disabled anymore, then the carrier can come back and complain?
The problem with that, Your Honor, is that Section 29 of the Workers' Compensation Law assigns that function to the court in the context of the settlement of a third-party action.
Okay, can the court order it?
The court can order it, and the court should have ordered. What the court ordered here is, we understand, we've got to look at what is...
What the court ordered here was a $50,000 upfront fresh money payment, right?
Well, Your Honor, without getting into the numbers, it wasn't, $18,000 was fresh money.
I'm sorry, okay, I'm sorry.
But whatever it was,
But they ordered $18,000 in fresh money up front.
That's correct.
Okay, is there any reason they could not have said, pay it on a weekly basis?
They could have in the exercise of their discretion.
And that eliminates any uncertainty, doesn't it?
It eliminates uncertainty, but it also imposes upon the worker the obligation of having to come back before the board. It frustrates settlements. The whole idea...
Well, on my hypothetical, I don't see why he does have to come back before the board. If the court had ordered a weekly payment, the burden would then be on the carrier to come
But
back.
that's not what the appellate division said.
I understand it's not. I'm suggesting that there might be a third way. That is not what either the Supreme Court or the appellate division did.
I think, Your Honor, the appellate division theoretically, the trial court could have done that. That was one of its options. But is that the issue?
And if the trial court had done it, would that not have eliminated the objection that the appellate division had to what the trial court did do?
It might well have. But that's not, Your Honor, with all due respect, that's not what's before the court. That's an option. Let's assume that's an option. The question is, did Judge Teresi abuse his discretion in doing what he did?
So you say option A would have been okay, option B would have been okay, but what the appellate division did, option C, is not okay.
Absolutely right. Because, Your Honor, let's go back and look what was before Judge Teresi in this case. Here's a police officer, 45 years old, sole support of his family, working before the accident, making $70,000 a year. After the accident, he was so severely injured that within a year he had to retire. He had to retire because of the disability. Under those circumstances, what was he able to make? He didn't sit around and loaf. This is like no good deed goes unpunished. He goes back to work. He makes $7,000 to $8,000 a year. The difference between his pre-accident earnings and his post-accident earnings is so large that there's no question that he is entitled...
He was working as a private investigator, wasn't he?
He was working as an accident reconstruction person. Yes, Your Honor.
Yeah, well,
I guess that issue is kind of on administrative appeal, right? As to whether he had an attachment to future employment.
Yes, Your Honor. And by the way, take a look at page 430 of the record in the appellate division's own decision in a case called Matter of Jimenez, versus Waldbaum, 9 Appellate Division 3rd. It was decided in 2004. In that case, what the court says, that if a person retires because of an accident and because of the disability, then if he doesn't go back to work, that doesn't, even if he has the capacity to do so, page 6 of the slip opinion in matter of Jimenez, even if he has the capacity to do so, that shall not result in a denial of benefits. When a person is injured, and as a result of the injury, he retires, the onus and the burden shifts to the carrier to prove that something else other than his disability was the sole cause of his no longer being entitled to benefits.
Coming back to the
extremely
facts
heavy burden.
Coming back to the facts of this case, would it be so extraordinary for someone who has his own accident reconstruction business to suddenly find that his income has tripled or quintupled in a year? I mean, it's a private business. You could get one big client and he could be making a lot of money.
Well, Your Honor, what you have to look at here is, as Dr. Abrams testified to, and it's in the record at page 61 of the record in his affidavit, and also at pages 151 and 152 in the depositions, this man had constant and recurring injuries that disabled him. He could work once in a while. Is it theoretically possible that he's going to have the case that's falling out of the heavens? Yeah.
Well, is it even that far? I mean, and maybe not even in this case, but certainly there are cases, it has happened, where a symptom like lower back pain can be very dramatically improved by the end of litigation. That when he knows that that the money is really his, and that he's going to keep it, not have to give it to the insurance carrier, he might work a little harder. It's not impossible.
If you're suggesting, Your Honor, for example, that there was some kind of malingering going on.
No, I'm really not, because I don't
Yeah,
see.
well, I
I
hope
should
not, because
disavow
there's
that, because
first of all,
let me ask my question. I do not suggest in any way that your client is malingering. I am suggesting that the risk of malingering is something that we have to take into account in framing a rule. Don't we have to do that?
Yes, you do, Your Honor. There is nothing in this record to suggest that.
But I guess what I'm saying is, it can be very, very hard to prove, and isn't there an advantage to having a simple, predictable rule for these partial permanent disability cases, saying that unless you've got a very strong reason to do it the other way, you always do it this way, and you don't have to sit around saying, do I really think he's malingering about his lower back pain?
No, because what this court said in 1983 was we want a rule of flexibility. We don't want a hard and fast rule. What you're saying here, Your Honor, is, okay, this is what the appellate division said, and this is what the carrier has been arguing. In every single case where a worker is anything other than permanently and totally disabled, that person is not entitled to the future benefits. At the very same time that the carrier is arguing that...
I still don't see why this whole dilemma isn't solved by paying in the future benefits periodically.
Well, Your Honor, at the very same time the carrier is saying this, they're exercising their credit. They're saying,
Mr.
we
Murray,
want credit,
Mr. Murray,
so you shouldn't even be able to come back.
Mr. Murray, I'm not sure that's what they're saying. As I understand it, if you take this simple case of a $300,000 settlement, and after the liens are paid, there's, let's say, $150,000 that the plaintiff receives. He or she is not going to get his or her permanent partial disability payment until that's been applied going forward, correct?
That's usually about 6 or 7 years ahead.
That's right. So
in this case. Yes.
That's right. So isn't the court saying it's far too speculative to say that there's going to be something in the future, 6 or 7 years down the road, to which you as the attorney are entitled to payment for when, in fact, when you got your settlement, presumably, you got the maximum you could possibly get, which would take care of all of this, so that having gotten all of this future credit applied, we can't say that in 2014 there's going to be something here that should make, in this case, the defendant pay more now.
Yes.
Is that the gravamen of this?
Sure. Well, 20. Yeah. Let's take 6 to 7 years. Okay.
Right.
Good scenario. In the 6 or 7 years, the carrier doesn't pay anything. It's got
That's
the
right.
benefit. Yeah, and it's had the benefit.
But that's why I asked you in the beginning. What we're fighting over is an attorney's fee. Because if it kicks in 6 or 7 years, they're going to pay it. They're going to pay the $400 until he dies, if that's what's necessary.
That's always been the law.
But you're not going to get an attorney's fee out of it, and that's the argument. The argument is whether or not you get an attorney, not you personally, of course, but any plaintiff's attorney is going to get a third of whatever's being paid 7, 8, 9, 10 years down the road till the time that the person either retires or dies.
we're not going to get any attorney's fees in 6 or 7 years if, after the credit period is exhausted, there is an obligation to kick in, because you'd be entitled to that under any circumstances.
As I understand
But
Judge
during that
Pickett's...
6 or 7 years, they haven't paid anything. Yes, Your Honor.
If it may I misunderstood, I think Judge Pickett's question goes into who's the real party in interest here. As I understand, the lawyer has already got every dime he's going to get. Is that correct?
That's correct.
And
by the way, it's not us.
Yeah, I understand. But the question is, yeah, they've taken it out of the award. The question is how much of it gets paid back to the worker and when? Now, in the future, or over the time in between? Nobody except me seems to think over the time in between makes any sense.
Well, over the time in between, if they don't pay anything over the time in between, they've gotten the benefit of not having to pay
I understand that. That's why I'm having trouble seeing how anybody could object to having him get $130 a week.
Well, the question is, Judge, if I'm going to say to you, you get $130 a week over the next 5 or 6 years, you're going to get $130 now. The whole point, and there's other cases in here under the workers' compensation law, where you say it's the present value. He gets it now. That's one of the benefits of the workers' compensation law, which, by the way, is supposed to be liberally construed.
He gets it now, but the carrier isn't getting the benefit unless and until it saves all that money it's going to pay him in the future.
But clearly your second choice to losing this case would be Judge Smith's resolution, would it not?
Well, yes. If that were the case, the answer is yes, Your Honor. But
isn't that what the appellate division was kind of suggesting in the dictum?
Well, what the appellate division was
the end of the decision?
Yes, Your Honor, but they were usurping the function of the court. They can't assign that to the board. There's nothing in the statute that 29.2 says equitable apportionment of attorney's fees by the court.
But we're agreed the court could do it.
If you wanted to correct that, I respectfully submit that's a legislative prerogative, not a judicial one.
So you say it's not an option. It's not an option.
Well, the hypothetical
You have to
question,
either win or lose.
the hypothetical question earlier, I think, is the way Judge Smith characterized it, was what if the court had ordered it as opposed to having it go back to the appellate division? What if the court had
You mean the
ordered,
board?
Yeah.
You mean as opposed to going back to the board?
As opposed to going back to the board. That was a difference. So, Your Honor,
But the court could order it.
the court could have.
Can we hold that the court should have ordered it?
Well, Your Honor, that's only if you believe that Judge Teresi didn't exercise discretion. You might remember in the function of I don't want to be presumptuous to tell you what the function of an appellate court is. You know it better than I. But what I suggest is you don't substitute your reasoning for that of the trial court unless the trial court abused his discretion. What Judge Teresi did on the facts of the case before him was to say, I'm not going to go for a hard and fast categorical rule. It's been 5 years since the accident. This police officer is earning less than 1/5 of what he would have to earn before he would lose his benefits. Is it hypothetically possible? Yes. But what we're doing here is we're substituting a theoretical, hypothetical possibility for the facts before Judge Teresi. This court may say, you know, we might have done it something different, but Judge Teresi didn't abuse his discretion based upon the facts, and the flexibility and discretion is inherent in the trial court. Thank you, Your Honor.
Thank you, Mr. Murray. Mr. Violando?
May it please the Court, my name is Michael Violando. I represent the respondent, St. Paul Travelers, and I'm happier to stand up here than I thought I would be when I got to this point because I'd like to answer Judge Smith's question. And the reason the court cannot direct ongoing payments of $400 is because it doesn't have the jurisdiction to do it. Only the Workers' Compensation Board has jurisdiction to award workers' compensation benefits into the future, and that's what we're talking about. The attorney's fees are going to come out.
The court has jurisdiction to award an attorney's fee.
And apportion them among the carrier and the plaintiff. Right. But they could not direct ongoing payments because those payments represent workers' compensation benefits. The main
Why can't they represent the same thing that the $18,000 in fresh money that Mr. Murray is asking for represents?
It's the same problem we had with the direction to pay the $18,000.
So you say they have no power to do that either?
Correct.
Okay, but if we were to, they do have power to direct them to pay, what is the other $32,000 that was, to reduce the lien by the $32,000.
And that's what 29.2 is meant to do.
So you say that the court never has power to require the insurer to put in fresh money?
Not if it represents workers' compensation benefits.
What if it's a total disability case?
Absolutely different. Kelly applies in a total disability
Then you
case.
present value the future benefit.
Absolutely.
So the court has power to calculate a future benefit, it has power to present value it, and it has power to order it paid today, but it doesn't have power to order it paid on a weekly basis?
I would take issue with the power to order additional payment today. What the court's function under 29.2 is to apportion the attorney's fee between the carrier and the plaintiff. That is in two forms, and by reduction of the lien and in satisfaction of what it derives as a future benefit from not having to pay benefits into the future. And that is the point, that is the crux of this case.
And you say there's no operation of discretion here at all, no room for discretion, there's just a hard and fast rule?
Not when it comes to awarding workers' compensation benefits, and that's what we're ultimately talking about. And that's why 29.4 confers on the board the jurisdiction to determine if there's any deficiency due after the settlement and after the apportionment of the attorney's fees.
Can Mr. Burns go to the board tomorrow and say, I'm still disabled, why don't you order them to pay me $119 a week until I'm not disabled anymore?
He has, and the board has determined that he's not entitled to anything after November of 2004. That's the board's recent decision that's attached to our appendix. Based on this decision, while simultaneously asking this court to overturn the appellate division's decision, the plaintiff petitioned the Workers' Compensation Board for the ongoing payments that they now say is too cumbersome process.
I mean, I should have seen that, and I didn't, but you're telling me that the board has interpreted the appellate division's decision as forbidding any kind of periodic payment?
No. The board has actually opted to exercise that process, and they have quickly implemented it, and they've been awarding ongoing benefits in similar cases.
Why did they not in this case? They thought he wasn't disabled anymore?
In this case, they determined they didn't have a sufficient attachment to the labor market. The underlying problem and the basic premise that is false and has been asserted throughout the entire process is that there's no question but that the claimant would receive $400 a week for the rest of his life. He appeared before the board and testified, resulting in that decision, showing that when he does choose to work as an accident reconstructionist, he earns far in excess on a weekly basis than he did as a police officer. He testified, I wish I could show you the transcript, but it happened after the appellate division's decision. The judge's decision is attached in our appendix, and he quotes some of the testimony from the claimant, and the claimant specifically said that he doesn't do anything to go out and try to build this business. He sits at home and he waits for someone to call. When someone
Claimant's
calls,
appealing that determination, isn't he?
And I disagree strongly with Mr. Murray. I think that's a very sustainable decision. Mr. Murray pointed to the Jimenez decision, which talks about involuntary retirement. There's never been a finding that this was an involuntary retirement case. The claimant did in fact retire and he's receiving retirement benefits, but that's different than the holding in Jimenez. And the appellate division addressed that in this case by noting Lieber. All Jimenez does is create a rebuttable presumption. In this case, it was rebutted, and the judge agreed that it was rebutted by the claimant's own inaction in trying to pursue any real
Putting aside the
income.
details of this case, in general, where someone has a permanent partial disability, where it looks like he's going to continue to have it for a long time, or at least to have enough of it that he will continue to hit the cap for the $400 cap. On your theory, and I guess under the appellate division decision, the claimant can go the next day to the Workers' Compensation Board and say, award me 1/3 of that $400 every week to make up for the attorney's fee?
That's the appellate division's decision in the dicta. at the end
That's
of the
your
decision.
reading of the appellate division decision. They don't say yes.
And the Workers' Compensation Board quickly implemented that, and they've been doing that for the last year.
You mean in other cases?
In other cases. It was petitioned in this case. They tried to secure the ongoing benefits, and that results in a trial hearing where the testimony of the claimant was secured, and he was questioned about his efforts to remain attached to the labor market, which would create his ability to receive ongoing workers' compensation benefits. The board in this case has determined that he's not entitled to any further benefits after November of 2004, which is paramount to the issue here, and it really underscores why Judge Teresi's initial decision was so incorrect. They ask us to give deference to Judge Teresi, and with respect to Judge Teresi, he was completely wrong in what the workers' compensation law requires. He was reading a permanent total loss of...
In fairness, even if Judge, when we defer to a Supreme Court justice's discretion, it's not because we believe that he's an infallible predictor of the future, because nobody is. It's because it was a reasonable decision in light of the facts known to him at the time. But I guess what you're saying is this example happens to demonstrate how really speculative the exercise is.
I couldn't ask for better facts to present this case to you, because in any case of a permanent partial disability, in order to receive those ongoing benefits that Mr. Murray says his client would clearly receive, he has an ongoing obligation to show an attachment to the labor market and to produce earnings records that would be used to calculate how much money he receives in workers' compensation benefits. The appellate division has set out numerous decisions, such as Meisner versus UPS, where they tell us that a claimant's a reduced earnings benefit is calculated by 2/3 the difference between what they actually earn in their light duty work as compared to what they earned before they were injured. And in this case, and in any case, you can't determine what they're going to earn in the future until they actually earn it and produce those records. People frequently have permanent partial disability classifications and have earnings increase over time, and their benefit dwindles down to nothing.
Mr. Violando, is that after exhaustion of the future credit?
It's irrespective of the future credit. The Workers' Compensation Board will operate regardless of the credit to determine what benefits are due, and an award will be made. If there happens to be a credit, it doesn't get paid. At the point in time where the credit is exhausted, benefits resume. There was a big discussion about, I believe it was based on your question, how the carrier has this great benefit by not having to pay ongoing benefits. The question is, what ongoing benefits would they have paid? If, as in this case, there were no ongoing benefits, workers' compensation benefits to be paid, then they had no greater benefit than their then existing lien out of that settlement. Mr. Murray has suggested that the appellate division usurped the legislature's authority in creating this pay-as-you-go scenario, and I would again submit that that was really dicta, and it wasn't the question that was presented to this court. And the appellate division was only asked to determine whether or not it was speculative to determine if the value of future benefits. And frankly, Justice Mercure's decision hits the nail squarely on the head in this matter. In every case of a permanent partial disability, there are going to be issues of attachment to the labor market, actual earnings if they're working. And none of those exist in cases of death or cases of permanent total disability or schedule loss of use. This decision by the appellate division does nothing to overturn Kelly. Kelly is still good law. Kelly applies where there's a death, where there's a permanent total disability or schedule loss of use award. Only where there are cases of permanent partial disability does this really become an issue. None of the cases submitted by either the Injured Workers Bar Association or the plaintiff have ever touched on this issue. It was really a case of first impression for the Third Department, who hears all.
Is it a problem that the Third Department's decision puts the burden on the worker to, even in a case where maybe this isn't one, but there are going to be plenty of cases where it's highly probable that that there's going to be more benefit to the carrier than is reflected in the reduction of the lien. Is it fair to put the burden on the worker to present that case to the board every time?
The burden is already there, because if there's a holiday, the claimant/plaintiff has to collect receipts for every medical visit, keep documentation of every week they would have otherwise been entitled to compensation benefits, and then when all of that adds up to the amount of the credit or holiday, then use all of that to petition the board for additional benefits. It would be their burden to show that that credit has been exhausted. So by doing it on a periodic basis, frankly, it works better.
Well, you say do it on a periodic basis. Presumably, the worker only has to make one application. Or does he have to come in every week and say, I didn't work last week, give me $130?
It wouldn't be weekly, but if they're working, it would certainly be annually with annual W-2s and earnings reports. We frequently see cases of permanent partial disability come back on the calendar just to determine.
What I'm struggling with is I don't see why it shouldn't be the norm that you continue to pay 1/3 of the $400, and the burden shouldn't be on the carrier to say, hey, he's not disabled anymore.
That was the appellate division's suggestion to the board, and that's what the board is doing. If there are no further questions, that's all I have.
Thank you, Mr.
Thank you.
Violando. Ms. Day?
Good afternoon. I'm Melissa Day, and I'm here on behalf of the Special Disability Fund as represented by the Special Funds Conservation Committee. And I'd just like to point out that Special Funds, as respondent, has advocated for the very position that the court has raised today, that this be on a pay-as-you-go basis. And I do not see a jurisdictional issue, because the Supreme Court can determine that since this is a case only involving a permanent partial disability, the matter should then be remanded back to the board for a determination as to what the claimant's entitlement or non-entitlement to benefits is, and then assess the percent cost of litigation, as it usually hovers around approximately 1/3, and direct the board to order payment to the claimant at that percentage against any benefits which might be due to the claimant.
And what about this case? You say that is the going forward rule, but what about this case?
This case, the claimant has been found by the board to not be entitled to any wage replacement benefits at this time, so there wouldn't be anything to assess the percent cost of litigation against as far as wage replacement benefits.
Well, I'm sorry.
The proposal has the dual advantage then of if the claimant does require further medical treatment, he can apply to the board to determine his entitlement to that medical treatment and to recoup the percent cost of litigation against the medical treatment as well. The Briggs Court struggled with finding that there wasn't anything, the claimant wasn't currently disabled at the time of the settlement, he wasn't entitled to wage replacement benefits, he wasn't currently treating at the time of the third-party settlement, and the court struggled with the idea that they couldn't find that there was no value to the credit that had been given to the carrier, but that there was just nothing that the claimant needed at that point in order to take as a credit against what the carrier received. This solution, as we raise on page 30 of our brief, has the dual benefit of not only addressing the benefits to which the claimant would be entitled to for wage replacement benefits and the very many variables that can go into that calculation, but also will make the carrier accountable to pay attorney's fees on medical benefits, which has been historically a very difficult benefit to quantify as far as looking into the future and trying to determine what that benefit is going to be to the carrier.
That you're to some degree disagreeing with Mr. Villando?
Yes.
He says the court can't do it. You says, well, the court can tell the board to do it.
Yes. Yes, Your Honor. I don't see a jurisdictional issue there. The board still determines what benefits the claimant is entitled to, and that benefit is an actual reduction of the credit to which the carrier is entitled. And that's a real benefit because that will hasten the time in which the claimant will be entitled to deficiency compensation. And if the board is involved in the process of requiring an accurate accounting of the benefits to which the claimant would be entitled, you're also going to see claimants who are going to be able to make claims for deficiency compensation where they previously hadn't been because 7 years had elapsed.
What are you suggesting that we should do? We should affirm here but say something about other cases?
Yes, Your Honor. My primary position here is that the permanent partial disability classification is just inherently speculative, and as Mr. Villando pointed out, the facts of this case couldn't highlight that better, and that the Supreme Court judge used a Supreme Court analysis to determine whether or not the benefits were speculative, rather than looking at this the way the board would look at this. And that's why the fact that this came out of the third department, the appellate division, which is responsible for hearing workers' compensation claims, is particularly relevant because the third department has an expertise in these matters and is very aware of the speculative nature of a permanent partial disability classification.
So what should this court say in your ideal view?
This court should affirm the appellate division's finding that a permanent partial disability classification makes trying to calculate a present-day value of the future benefit to the carrier too speculative. And so therefore, in those situations, Supreme Courts should order the Workers' Compensation Board to determine the benefits that the claimant would be entitled to under the statute and continue payment at the percent cost of litigation, whatever the disbursements and the attorney's fees are versus the gross settlement.
Which Mr. Villando says they're doing, right? That the board is doing that.
Yes, the board has already implemented this on other cases.
Is that starting immediately?
The board took it and ran with it.
I mean, let's assume this case settles and there's a future credit of $100,000. Does the board, starting tomorrow or the next month, make an allocation at that time?
The different parties have taken different tacks on this. The position of special funds is that as the justice has brought up, that you just continue that payment to the claimant automatically. And if you take
But no, he's not receiving any money.
No, this particular claimant is not. But
no, in any claimant, as I understand it, once you settle the case and there's $100,000, let's assume everything gets paid, there's $150,000, the attorney takes his $50,000, then there's $100,000 that gets applied as future credit to the carrier. All right, so he doesn't get paid until $100,000 worth of benefits is used up. You're not suggesting, are you, that starting the next month after the settlement, that one-third of whatever the claimant would have gotten gets paid to the attorney, are you? Because he's already been paid.
Not to the attorney. I'm suggesting that the parties should voluntarily continue those payments to the claimant, because that first week the carrier doesn't have to make that $300 payment. It's now benefited by it. And it should voluntarily.
Let me interrupt you. What that means is that the $50,000 that the lawyer got of the $150,000 is really an attorney's fee that should have been paid by the fund, because they're the ones that are benefiting from that settlement, that gets them the future credit. So rather than the 1/3 being paid by the carrier, it seems that the attorney should put his $50,000 fee that brought that $100,000 into existence into escrow, and each week that comes in ought to give 1/3 of it back, because that's money that the state insurance fund, or that the third party should have gotten credit for, not him, right? Because he's now done the work for the carrier.
Our position is that the party that enjoys the benefit should bear the cost of the attorney's fee until that benefit becomes the other party's. So as the carrier exercises its credit at the board, that first day that it doesn't have to pay $1 to the claimant because it has a credit, the carrier then has to reimburse the claimant for the attorney's fees that he bore up front. It has no effect on when the plaintiff's attorney gets paid. That lien is primary.
And why doesn't that apply here?
That will apply here in that a credit will exist and remain on this claim until the board determines that the claimant is entitled to something under the workers'
So
compensation
why isn't
law.
it a reversal then and a remitter?
Because at this point, the claimant isn't entitled to anything at the workers' compensation
Do we
board.
know that finally and flatly for sure?
Not finally and flatly.
So then why isn't a remittal appropriate?
Because we have the threshold question of, number one, whether or not a calculation of the present value to the carrier is speculative when the claimant's been classified with a permanent partial disability, which is a pure issue of law. And then secondly, the decision that the board ultimately makes on whether or not this claimant is entitled to benefits isn't dependent upon how this court rules today. If the claimant is ultimately entitled to wage replacement benefits, then the board will reverse the decision of the workers' compensation law judge and direct a reimbursement to the claimant of the 34.82% attorney's fees against the benefit that he now is entitled to because the administrative board has reversed the decision of the judge.
I see. So he could prevail even though we affirmed.
Correct.
Okay.
And then thank you, that's all I have.
Thank you. Mr. Murray, do you have
Thank
anything
you. I
further?
know I have 1 minute, Your Honor. Very quickly to Judge Smith's point, this is what happened. It's the proverbial catch-22, heads I win, tails you lose. I'm quoting from this decision, which should never be before this court, by a low-level ALJ that is even appealed yet within the board that's confusing everybody. He said, in effect, the claimant is petitioning the board and the Court of Appeals for opposite relief. He's saying, look, you can't get this because you're up in the Court of Appeals right now asking that the present value of the future benefits be awarded, the carrier's share. At the very same time, he's saying the reason you can't get that is because you're asking for opposite relief. We're only doing what the appellate division told us to do while we're appealing to the Court of Appeals. So the problem is the ALJ said, look, you can't go to the Court of Appeals and ask for the present value of future benefits and come before us. That's what they said. Then gratuitously, they inserted this statement about the fact that he's voluntarily withdrawn from the labor force. That is a poor decision by the ALJ, which we haven't even had a chance to get to the appellate division yet on. When we go to the appellate division, we're going to assert their decision in matter of Jimenez. The amount of the benefit extended to a permanently partially disabled claimant is 2/3, and if he becomes involuntary because of disability to seek employment despite capacity to do so, will not result in a loss of benefits. That's the point. The fact that he's withdrawn from the labor market now is irrelevant because he retired because of the disability, and he disputes that, but I respectfully refer the court to sections or page 61 of the record in the affidavit of Dr. Abraham, which indicated clearly, I told this guy he can't work anymore. I've seen what's happening here. He's got to retire, and indeed he retired just